Thank you very much for joining us on The Law. This is your legal light and your help law. And I'd like to say, express my appreciation to Blay for sitting in for almost 1 month in my absence. Thank you so very much. Now, why do you take up the nationality of another country in addition to Ghana? What are the benefits or the disadvantages? Ghana's 1992 constitution prohibited dual citizenship. It was, however, amended in 1996 to allow for dual citizenship while denying such citizens of holding certain public offices. The Citizenship Law 2000 adds to the list and outlines qualification and deprivation procedures. Persons who desire to serve in public office cannot swear allegiance to another country. The law seems to have brought trouble to many, especially politicians. Former Boku Central MP, the late Adamu Dramani Sakande, was jailed 2 years by an Accra Fast-Track High Court for perjury and forgery after failing to prove he had renounced his American citizenship. Many have lost the chance to serve their country because of dual nationality. The latest is James Jachi Kwesin, whose title as the MP for Asin North has been rocked by a Cape Coast High Court because he's been held to be both a Canadian and a Ghanaian citizen. He has appealed that decision to the Court of Appeal. His case borders more on dual citizenship and allegiance. Let's check him out after all these developments and return to the desk to ask the question, what's the difference? And is it a good move that we're seeking to amend the law to remove all the prohibitions?
The court directives is there, but also there's a process that you take after such pronouncements of rulings or whatever, which I have satisfied all the requirements. I'm not going to go into details of that. And so, so long as I know, based on those processes that I have also initiated and make sure they are in place, it still gives me that opportunity to stay as a member of parliament for Asin North. And for that matter, any committee that I belong to in parliament, which is also extension of parliament, equally binds my membership. So that's why I was in the meeting. I have always said that I'm a type of individual that respects law and order. I've lived in a country that has always given human rights and privileges to all citizens. So being a part of the committee, going back to that is, again, is the law of the land of our country, our beloved country, Ghana. So I'm still a member of parliament based on the rules that I have engaged in and also the legal proceedings and advices.
We are prepared to take this all the way to the Supreme Court. You must have heard that an aspect of this matter went to the Supreme Court yesterday. So the substantive matter, yes, we are prepared to take it all the way to the Supreme Court. And if we are up to the level of review, if it so happens. So for now, we want to urge every party member and every concerned Ghanaian to remain calm whilst we consider the legal remedies available.
majority of parliament can create a new class of citizens. So parliament can just get up and say, well, if you are a good soccer player, you become a citizen of Ghana. That's okay. That's okay. They don't need anything more than the 2/3 majority. But then there is what I call the rights, the political rights. Those, my friends, are entrenched. That basically means even if all parliamentarians got together and said, we are going to isolate citizens that live on the border, or dual citizens, or citizens who are religious, and we are not going to allow them to vote. We are going to deny them space in the political arena. The Constitution says, you can't do that, even if all of you want to do that. The only way you can do that is via a referendum. That is very important. It is the entrenched rights. And this will become very important, my friends, because I'll show you that Parliament has created a class of citizens and have taken rights from them. Parliament cannot do that because that can only be done by referendum. By conflating status and rights, Parliament created a class of citizens that the Constitution itself does not allow.
Right. So you just heard the embattled member of parliament there, and also another member of parliament, Roxanne Nelson Dafiamapo, explaining further that they intend to take the matter to the very top. Then you heard Professor Kweku Asare. He's a D&D fellow in public law and justice. He's a fellow of the CDD Ghana. Of course, you have become aware that there is an amendment process proposed for all of these, inhibitions or prohibitions to be removed. The prohibitions that if you hold dual citizenship, you cannot hold certain offices in Ghana. We'll lay out all those offices for attention. But we're interested in knowing from you, why do you choose another country's, citizenship in addition to Ghana or to the exclusion of Ghana? And why do you do so and still seek to want to participate in certain processes in Ghana? Do you subscribe to the process that is being started to remove all the obstacles so that dual citizens can have the same, rights, including privileges like you also have? Here in the studio is Dr. Justice Sremsai. He is lecturer at the Gimpa Law School. Thank you so very much, Justice, for making the time to join us.
Thank you so much, Samson.
Right. Professor Asare is joining us via Zoom. Thank you very much for making the time, sir. Please unmute your mic.
Yeah, thank you, Samson. I was expressing my appreciation for you inviting me to the panel and for getting your audience to hear my views on this important subject.
Tell me, you saw the video of you that we played. That was how long ago? You must have forgotten about it.
Yes, I was actually very surprised. And I said to myself, where did Samson get this from? I have to be more careful what I say these days, All
right. Very good to have you. Okay, so let's open this debate. Ultimately, we want to educate our viewers, and there are very many people who are interested in this subject, lawyers and very many professionals who have indicated interest in this discussion, and so are presently tuning to listen and to also contribute. At the right time, we will open the phone lines so that you share your views and your contributions with us as well. So let's begin with Dr. Justice Sremsai. Citizenship versus allegiance. Of course, on this show, we do pure legal education. This is a legal clinic. But we know that certain things have happened recently that can help people to better appreciate what is going on. So what's the distinction between the two, if there is any?
Yeah, thank you very much. And let me also say hello to Professor Asare. When it comes to Ghana, we usually have our favorite sitting. Last month when he was in Ghana, we couldn't meet, unfortunately, but I'm happy to meet him on this show this afternoon. Now, citizenship is simply a concept which is used to sum up the relationship between a sovereign and an individual. In other words, if you're a citizen of a country, you are deemed to be under the protection of that country or the sovereign who reigns over that country. So that is citizenship. Now, allegiance is also a concept which speaks to the other side of citizenship. Let me take us back to some philosophical background so that we can understand this concept better. And also to understand that the two concepts become relevant mostly because of international law. So you cannot really understand this concept unless you view them from the perspective of international law. International law is the law that regulates the relationship between states. So when you are questioning someone's citizenship, especially dual citizenship, automatically you are dealing with the relationship between two states. And also when you are talking of allegiance, automatically you are dealing with two states. Now, back to philosophy. I believe you understand, you recall those days when we were doing philosophy, something about the social contract theory. That contract, put two, categories of people against each other in the contract. We have the sovereign on one side and then the citizen or the subject on the other. Now there's a contract between these people which is called the social contract. The sovereign has undertaken as part of their consideration for the contract to protect the citizen. And then the citizen on the other hand has also undertaken in return for that protection to pay allegiance or to pay loyalty to the sovereign. So these two concepts, citizenship and allegiance, come together to form and embody that concept as a consideration from the sovereign and also the citizen. So within this framework, you will begin to understand that once you enjoy protection from a sovereign, under international law and under jurisprudence, you are bound to pay allegiance to that sovereign. And when you question that allegiance, either by paying another allegiance without the approval or authority of that state, you pay another allegiance to another state, you become what we call a dual citizen. And then your fundamental basis of allegiance becomes questionable. It is purely a political question for a state to decide that I can allow my citizen to be a citizen of another country. That is one. Or, in addition to that, I can allow my citizen to pay allegiance to another country. It's kind of, let me bring it home, something of polygamy. Let's take polygamy for instance. So here, the citizen will be the man, and the woman or the wife will be the state. Now, in a polygamy relationship, the woman is saying that I don't have a problem with my man being another woman's wife, a husband. And in that sense, you become a dual citizen. You pay allegiance to two women, and both have agreed that this should be the case. That is how we need to look at this. Now, if you have a country, a particular country, which says that, well, I am not able or willing or ready to entertain my citizen to be also a citizen of another country or to pay allegiance to another country, it is totally and entirely within the framework of that country to make that decision. And that decision is a political question. And it's not answerable in law, because then it is a decision that sovereign has taken to allow its citizen to become a member. Now, there's a range of rights that come with that. There are countries which allows their citizens, there are countries which allow their citizens, to be dual citizens and still hold all the rights that mono citizens, are entitled to. That again is a political question that every country must take. Some countries will say, well, we don't want this caliber of our citizens to hold this particular position and still be paying allegiance or be citizens of another country. That is also within their decision or their right to make. So we need to draw a line between two things. One, the political question, whether you want your citizens to have dual citizenship, and also whether you want all of them to have the same right. Those are political, questions that you need to answer.
So in 1992, when we brought the Constitution into being, we said, we don't want you to be a dual citizen. You are prohibited from holding the citizenship of Ghana at the same time with another country.
Precisely.
If you went to a country that said, by marriage, you became a citizen of that country exclusively, you were not a citizen of Ghana until you have renounced or that marriage has been annulled. So we took that decision. But in 1996, we realized that there was no sense in it. So we amended the Constitution and said, you can be a dual citizen. You can be a Ghanaian, you can be a British, you can be, a citizen of the United States or anywhere else, except that we will not allow you to enjoy certain privileges, if you like, occupying certain classes of offices, being an ambassador or high commissioner, being secretary to the cabinet, being the chief of defense staff or any service chief, being the inspector general of police, commissioner, customs, excise and preventive service, that's GRA now, director of immigration service, and any other office specified by an act of parliament. And we have seen that we have passed many other laws, including very recent ones, like the Office of Special Prosecutor, and we have proscribed being a dual citizen and holding that office. I like the example with which you sought to explain it using the polygamous marriage. Professor Asare, yes.
If I could just...
okay.
So the explanation you give and the illustration about the 1992 Constitution and subsequent amendment in 1998, that 1996, that is what I meant by political decision.
Right.
To come to these decisions, there are so many variables that a state may analyze and then come to a conclusion that this. So, for example, when we took the decision that we were not going to allow our citizens to be dual citizens, it was based on certain reasons. Those reasons were political. They were not legal reasons per se. Then when in 96, we took a decision again to allow dual citizenship, that was also based on a number of variables. And I believe as the program goes along, I will highlight some of these variables and make comparisons with other states and the variables and how they handle these situations.
Right. So in trying to make the distinction, Professor Asare, our Constitution appears to be very clear in making a distinction between a dual citizen and someone who owes allegiance to some other country. Can you help us to, make the distinction before we move forward?
Yeah, Samson, thank you again, and it's good to see my good friend Justice Sai. As he said, I missed him when I was in Ghana. And today, I appreciated that he posted a case based on customary law, the Apenkwa case. And the Apenkwa case probably illustrates the importance of allegiance, as well as the distinction between allegiance and citizenship, which many people fail to draw. And because they fail to draw that, they make all kinds of
Okay, so Professor Asare's internet is frozen, but we are hoping that it will normalize quickly so that we get him back. He's going to do a certain distinction, which is important. And we made a reference to the Asare North MP's case, which eventually, turned on allegiance, that he owes allegiance to Canada. Now, Prof, thank you very much. Your line froze, so start all over again.
Yeah, so I was saying that people sometimes equate allegiance and citizenship. They may be related, but they are not the same thing. And the best example of that will be the case of Rawlings versus Bilson, or the other way around, Bilson versus Rawlings. There are two different cases, Bilson versus Attorney General. That's not what I'm referring to. I'm referring to Bilson versus Rawlings. If you read that judgment,
Okay, so we're just having a little difficulty with Prof's line, but I hope that it will resolve quickly so that we bring him on. And he's beginning to do the distinction between dual citizenship and allegiance, which some people almost always mix. But if you look clearly in the Constitution appears very clearly to make a distinction. How can he help us to appreciate that distinction? Even before we go on to now ask the question, why should we remove the present prohibitions against dual citizens from holding certain public offices? Prof is back. So Prof, you were starting on the note of Bilson versus Rawlings.
If you read that case, the judge basically says it is possible for someone to be a dual citizen, in the case of Rawlings, to be a citizen of Ghana and, let's say, United Kingdom. But that in itself does not mean he owes allegiance to a country other than Ghana. And that is the point, that citizenship is not the same thing as allegiance. And I like the way you laid it out when you started, because when we promulgated the 1992 Constitution, dual citizenship itself was not even allowed. And yet, there was this proscription in Article 94(2)(a), which said a person who owes allegiance to a country other than Ghana could not, number one, belong to the legislature. Number two, he could not belong to the executive. Number three, he could not be appointed to any constitutional commission, such as the Public Service Commission, the Electoral Commission, the NCC, the Regional and Lands Commission, and so on. Fourth, and most important, he could not be a founder of a political party, he could not be a leader of a political party, and he could not be an executive of a political party. Now, one.
Okay, so I suppose that challenge must be coming from Prof. Asare's end, but we should get that clarified so that we move on once and for all without that particular inhibition. So he's making what should be the distinction between citizenship and allegiance. And I like to say dual citizenship and allegiance, but it's actually citizenship and allegiance. Can you be a citizen? Yes, Prof is back. Thank you very much, Prof. Yes, you can continue.
The sheer breadth of exclusions should tell us something, that when they use allegiance, they were not equating it with citizenship. And we know that because we already established that dual citizenship itself was not allowed. And so it would have been nonsensical to have Article 94(2)(a) addressed to dual citizens. And Article 94(2)(a) has basically been a dormant article, basically not applied to anybody until Act 527 was passed. Act 527 is what you were describing, the act that allowed for dual citizenship. And once that act was passed, then somehow this dormant article erupted like a dormant volcano to sweep about 10% of the population of Ghana, because the international, the IOM estimates that Ghanaians who are dual citizens comprise of about 10% of the population. That is 3 million. And I believe that's even a conservative estimate. So if we continue to apply this dormant clause which was never meant to apply to citizens, dual citizens, because there was no such thing, to this new class of people that we are calling dual citizens, then we are basically creating a country where 10% of our population cannot belong to the legislature, cannot belong to the executive, and due to some additions that were made subsequent to the passage of Act 527, cannot sit on the apex court, cannot belong to the high rank of the security service, cannot even be chief fire officers, cannot be special prosecutors. You ask yourself, how is it possible that you do something that is lawful? Because taking the citizenship of another country itself is lawful. How is it possible for you to do something that is lawful and for these penalties to be imposed on you? Another way to look at the problem is to go to Article 94.2a itself. When you go to Article 94.2a itself, you see that the type of exclusions there
we'll get Professor Asare to exhaust his point on Article 94.2, and then we'll bring in Justice Stramsai again. What are the indices of allegiance that makes it possible to be a citizen of one country and yet be able to owe allegiance in different ways? Is it not a natural consequence of citizenship? Is Prof back? All right. Yes. Prof, so you were now going into Article 94.2.
Yes. And the reason I wanted to go in there was to establish that Article 94.2 was meant to apply to a very limited number of people who have engaged in acts so egregious that it was believed okay to exclude them from these many positions that I've highlighted. So you would see that it includes someone who is a bankrupt and is yet to be discharged, or someone who is adjudged to be of unsound mind, or is detained as a criminal lunatic, or someone who has been convicted for high crime under the Constitution, or treason, or for an offense involving the security of the state, fraud, dishonesty, moral turpitude, and so on and so forth. If you look through that list, it is hard to interpret allegiance in a way that says it applies to somebody doing something that is lawful. It takes an almost extreme view of allegiance to place it in that category. Now, I want to, are you still with me?
Yes.
I want to explain why we amended the Constitution in 1996, because we were not the only country that joined the bandwagon to allow dual citizenship. By 1990, only 20% of the countries in the world are allowed dual citizenship. By 2010, it was about 80%. And that is because the way countries and philosophers started to think about citizenship changed fundamentally. Originally, citizenship was viewed in the way that Justice Sai described it, as some sentimental thing. It was some immutable, sacred emblem of national identity that was meant to be exclusive, and that was also meant to be territorial. And that made sense in the 17th century and the 18th century and even some part of the 19th century, because people were not highly mobile. If you wanted to move from Accra to London, you went to the steamer. It took you 6 months to go. And when you went, you never came back. People were not mobile. And we conceptualized citizenship in the same way we conceptualize a filing system. In those days, a file could belong to only one physical cabinet. There was a cabinet, you took somebody's file, and you put it in that one cabinet. It was hard to contemplate that a file could belong to multiple places. And in that context, where it was important to place somebody in only one box, the question of allegiance was extremely important, because in those days, there was a question of who would fight for a country. Countries competed on controlling their people because they needed them for war purposes. And United Kingdom was the first to propound this allegiance doctrine in a famous case called the Calvin case. By the way, the Calvin case is very similar to the Apenkwa case that Justice Sai posted today. And in the Calvin case, it was established that allegiance is permanent and indivisible. That is natural allegiance. So if you were born a British subject, then you would always remain a British subject, and your own actions cannot negate that allegiance that you owed to the king. You can see that it originated from the feudal law, because in those days, the lords will grant their vassals some land, and as a result of their getting that land, they were permanently indebted to them. And they borrowed this concept in creating this natural allegiance theory with the intention to be able to impress their citizens who moved to the New World. So if you moved to America and you took on American citizenship, the British did not recognize it. They still considered you to be a British. Why? Well, because they wanted to be able to impress you if there is a war. And they used to do that. In fact, there is a war, the War of 1812. The War of 1812 was fought because of this impressing of former UK citizens who had migrated.
All right.
The world changed in its thinking about citizenship when the Americans propounded the expatiating doctrine. At that point in time, citizenship was viewed more as elective. Today, because of mobility and so on, we have even moved past elective citizenship, and people now conceptualize citizenship as a commodity. It's what they call strategic citizenship. It is very possible to sit in Ghana. If you have $1 million, as an example, you could buy the citizenship of any number of countries without ever going there. Allegiance these days has very little to do with citizenship.
Okay.
It is.
That's a good note to hold on for me. And then, so just as I was asking a question that he appears to preempt, that is it not the case that you can't fault those who view allegiance and citizenship to be the same, because allegiance is the product of citizenship. It's natural.
Yes, so Prof was right when he said allegiance is not the same as citizenship. But what Prof has not told our audience is that allegiance is like the umbrella word. Then under it, there are so many elements. So there are so many things that will make you pay allegiance to a particular country. Citizenship may only be just one of them. So for example, if you are not a citizen of the US, but you work with maybe CIA, and you take an oath of allegiance because you are working as an agent for the CIA or any of those high security entities in the US, you pay allegiance to the US state without necessarily taking up citizenship. So it is true that citizenship is not the same as allegiance, but it's just one of the indicators. So if you're a citizen of a country, the presumption is that you owe allegiance to that country. Let me give you an example. In the American system, every country deals with this citizenship and allegiance issue. And they all understand citizenship to be one of the ways of allegiance. Because if you're a citizen of one country, the laws, some significant laws of that country applies to you wherever you are. And you are also entitled to the protection of that state. These are fundamental principles which no one can dispute. Now, if in the American system, they have something called the clearance, security clearance. As you work in American government system, public service, and you climb up, you need levels of clearance to hold higher positions. So there are three main, the first one usually will be your what we call the public trust, assessment. They deal with, that is when you are entitled to, when you have access to basic information. As you climb up, you have three levels of security clearance. The first one is confidential. The second is secret, and then we have top secret. To clear you to attain a certain level, they will have some factors that they look at. One of those factors will be allegiance, your allegiance to the US as a country. Then they have something called foreign influence, and then they have foreign preference. Under foreign preference, there is something called taking up of dual citizenship of another state. And then there's another one we talk about your residence and then possession of passport. So these issues we are discussing is not something that is strange or new. These are things that other states, even powerful states, consider in allowing people to climb up the political or the public service ladder. So it is also not very accurate when we create the impression that citizenship is a useless concept or the concept of allegiance has lost is relevant. It has never lost its relevance. It's still relevant.
So someone may ask the question, if by being a natural-born Ghanaian, I am automatically seen to have allegiance and have allegiance to Ghana, why do I have the requirement of having to now swear allegiance or pledge it to Ghana when I'm taking an office? Almost every public office holder must, swear the oath of allegiance to Ghana. It doesn't matter that they are natural-born Ghanaians. How do you explain that?
Yes, so there is a concept of what we call active, what we call active allegiance. Okay. If you go back to the Bilson case, the court drew that distinction. That Rawlings naturally, is, how do we call it? It's also British because of his father. And that is natural. And then he's Ghanaian, which is also natural. But the question was, has he done anything active? Has he done anything to take allegiance to pay allegiance to the British crown or not? So that resolved the issue, right? So when you have a natural Ghanaian who has actively taken a passport or has acquired a citizenship, that is an active step you have taken to acquire. So that becomes an indicator. I'm not saying it's absolute, but it's an indicator of your interest to owe allegiance. So we need to break down the issues to be able to understand the nuances. It is not a very simplified or simple topic that you can just say, if you're a citizen, then this. If you are not citizen, then this. Because even within citizenship, other countries have levels of citizenship. They have subjects and they have citizens and they have all manner of divisions among them. Our system is not much advanced. Maybe that is why what Professor Asare is pushing will become relevant in the sense that it will compel us to also make different distinctions and explain some of these concepts within.
Will it be a positive indication that even though I have American citizenship and I have Ghanaian citizenship, once I swear an oath in Ghana and say that my allegiance is to Ghana, that will be the end of the questioning about my allegiance?
Not necessarily, not so.
What are some of the things I will do in Ghana that will show that despite my holding US citizenship in addition to Ghana, my allegiance would rather be defined as being in Ghana than in the US?
Again, the question of our constitution has made it clear that if you owe allegiance to another country, automatically you can't hold certain offices.
Yes.
Okay. So if you, for example, I mentioned maybe taking oath of allegiance to any of the public services in the U.S. If you do that, that is one of the things that you have done, which shows that your allegiance is towards a country in addition to Ghana.
Right.
So you can swear allegiance to Ghana, and it's also possible to swear allegiance, sometimes even secretively, to another country. So in the foreign countries like the U.S., to give you clearance, if they check your background. So if they realize that you are a citizen of Ghana, for instance, or you have had any kind of relationship with Ghanaians or a Ghanaian authority, whatever, they actually send people to Ghana to conduct intensive investigation. And some of the things they look out for is your residency, your conduct. Have you ever been engaged in things that show that you support Ghana, or you are in opposition to the U.S. policy on this? They do all that. So if you have the resources, I would say that the best way is to adopt that kind of system where you seek clearance for anyone. So, for example, in this MP case, for instance, if he was a U.S. citizen and they wanted to give him that clearance to hold that kind of, if you want access to certain level of clearance, they would have conducted information. They would not just simply say that by merely being a citizen of Canada, you are disqualified. You are eligible. But in terms of qualification, you will need clearance. And the clearance will establish whether, apart from your holding of passport or being a citizen of Canada, you have done things that actually, raise your things that raise your question.
How do you use Boris Johnson's case to explain this situation? That he's a citizen of the U.S. until he just recently renounced it. He's a citizen of the U.S. and he's a citizen of the U.K. and becomes the prime minister.
Well, I am not familiar with the details of his citizenship.
Okay.
But he would have definitely been advised, to renounce that. Because you see, the point is that people who hold high offices, they have access to certain information.
Right.
If you take some countries like China, a Chinese citizen could be commanded by Chinese authorities to deliver some information which is in his possession to the Chinese government. And if he refuses to do that, it's a serious crime which China may use other means to enforce.
Right.
So what these laws generally, or these clearance issues generally try to prevent, is a situation where even though you are a citizen, you have access to classified information, but then you are subject to other countries' jurisdiction where they can force you or compel you to... Let me just give you an example. Imagine a U.S. president, who is also a Chinese national. Or a U.S. minister, secretary of state, who is also a Chinese national. What do you think will be the situation? Or a Russian, U.S. secretary being a Russian, So we need to have in mind some of these things, and that's what I meant by it's a political decision that countries have to take. And in taking those decisions, they take a number of factors into consideration. So it is not simply a matter of you are a citizen, you are not a citizen. There is an essence, what we call the purpose of the law is not to just say if you are a citizen, then you do this. If
as we understand in the US, only natural born citizens who are also resident in the US for at least 14 years may run for the office of president. And this is irrespective of the fact that such a natural-born citizen holds the citizenship of other countries.
That's true.
It's the same thing in Nigeria. Let me use that, then come to ask you whether you think that what we are seeking to do with the amendment that we are seeking to introduce is good or it's not good. So presently, you can be a Chief Justice, you can be a Justice of the Supreme Court, you can be an ambassador, you can be a high commissioner, you can be secretary to cabinet, you can be chief of defense staff, or any chief of staff, service chief. You can be inspector general of police, you can be commissioner customs, you can be director of immigration, you can be commissioner value-added tax that it used to be, you can be director general of prisons, you can be chief fire officer, you cannot be chief director of any ministry. You can't get to the rank of a colonel in the army or its equivalent or any such security services. All of these things, by virtue of the new amendment we are seeking to introduce, will remove them, good or bad?
Well, naturally, I am a human rights person. So anything that extends rights to people, I am for it. So, but the issue here is not what I want or not. My only submission is that in doing this, let's not deny certain legal principles or misconstrue them so that we can convince people to come to a certain conclusion. All I am saying is that let us appreciate that it is not an irrelevant concept. Allegiance is not an irrelevant concept. Let us understand that there are real consequences that may lead to, international, role between states. So we need to address each and every one of these issues in amending the law. But if we have to deny the relevance of allegiance, we have to deny the relevance of citizenship and reduce all the concepts as if they don't matter anymore and that they are archaic, then we end up making a very big mistake. Let us be very mindful of these real issues. For example, if you argue, for instance, that you cannot do something lawful and get punished for it, I think that proposition is enticing, but doesn't stand fair, because we know that to be a chief is lawful, but here if you're a chief, you are not allowed to play active politics. We know, for example, that if you to be a chancellor of a university, it's a lawful act, but our presidents are not allowed to be chancellors of the university. So, some of these comments actually take away from the weight of the matters we are trying to.
Okay. Let me get back to Professor Kwaku Asare on the proposed amendment that will do away with these prohibitions. How do we stand to benefit by these? Please unmute.
Excellent question. Before I get to that, let me state a couple of things. That even in Ghana, it's only the natural-born Ghanaians who can be president and vice president. Secondly, when we talk about dual citizens, I put them in 3 buckets. Those I call audition runaways. These are natural-born Ghanaians who have emigrated and become citizens of another country. Then for lack of a better term, tongpeng. These are non-Ghanaians who have moved to Ghana and have naturalized as Ghanaians. And then we have the Kwesi Broni. Kwesi Broni is somebody who was born a dual citizen. So at birth, his father was from Ghana and his mother was from Egypt. A good example would be Fatia Nkrumah and Kwame Nkrumah and their offspring. So we have to be careful when we are talking about these things. And we have to also note that, in my mind, to the extent that we want allegiance to mean anything, we go to the English, and under the English law, natural allegiance is that which you owe at birth and that which cannot be, you can't get rid of. So a Ghanaian is always a Ghanaian. That's the concept there. And when you accept that concept, then you have to start addressing who Article 94(2)(a) was addressed to. And I think that it was addressed to, in my categorization, those that I call tongpeng, those people who owed natural allegiance to other countries who have now become Ghanaians. It was them, to the extent that it makes any sense, that it was addressed to them that you cannot get rid of your allegiance, and so you owe allegiance to a country other than Ghana, and therefore fine would allow you to register as Ghanaians, but for certain positions will not allow you to do it. This goes to the example Strem was giving about somebody who is a Chinese and become.
Professor Kwaku Asare's connection has not been the best. This little freezing that happens, this is the law. It is your legal light and your health law. And I have been having a conversation with Dr. Justice Shramsai and Professor Kwaku Asare. We are looking at the question of citizenship versus allegiance, and we are now getting ultimately to whether or not it is good to consider the bill for the amendment of the Constitution to allow dual nationals or citizens of Ghana to hold all the offices and enjoy the privileges that they have been denied over the period. Prof, please continue.
Johnson basically gave up his U.S. citizenship. It didn't have anything to do with what Strensai was speculating. He gave it up because he didn't want to pay U.S. taxes, or he thought U.S. taxes had become too much. Now, let us interrogate some of the reasons why people are a little worried about dual citizens. And by the way, all these arguments that are being made, they are not very new. We encountered the same arguments in 1996 when we were trying to allow Ghanaians to become dual citizens. All these arguments were raised. Some of them were, oh, well, they have divided loyalties. They will be confused if there's a war between Ghana and Nigeria as to who to fight for. They can chop our money and run away. They want to eat their cake and have it. They will compete unfairly against politicians. They will take jobs away from mono citizens. They are not full Ghanaians. You cannot serve two masters. These are the typical arguments that are made in terms of restricting them from holding office. Now, when you interrogate these things, you find that they are entirely speculative and are not grounded in any empirical reality. As far as I know, no dual citizen has ever betrayed Ghana or been involved in overthrowing the Republic of Ghana. In fact, anytime the Republic was overthrown, it was done by some mono Ghanaians. And even though mono Ghanaians have overthrown the Constitution or the Republic, it will be unfair then to say because 1 or 2 or 3 or even 10 mono Ghanaians have overthrown the Constitution, let us now be suspicious of all mono Ghanaians and exclude them from holding these many offices that I enumerated. Let us consider the case of a Ghanaian who is also a Nigerian. And reasonably or conceivably, one could argue that, well, look, if you are a Ghanaian and a Nigerian, you shouldn't be the ambassador of Ghana in Nigeria, maybe. But what is the reason for excluding this person from becoming the ambassador in the 192 other countries that he has no affiliation with whatsoever? The exclusion is just overbroad because basically this is something that you should leave to the appointer, for the appointer to exercise discretion that, look, hey, because you are from Nigeria, I want you to be an ambassador. Maybe I'll send you to be an ambassador of France, but not to Nigeria. Then there's this idea that if someone is a dual citizen, he can come and commit some crimes in Ghana and then run away. It doesn't work that way. In fact, yesterday, I read an update from the Justice Department in the US where Ghana had helped them to extradite a Ghanaian who had violated the US law. And so there are extradition laws that deal with these cases.
All right.
Can I go on and quickly tell you some of the reasons why?
In 1 minute. Okay. In 1 minute.
In 1 minute?
Yes.
Well, of course, all hands on deck. If you are a Ghanaian, we want you to be involved. Number 2, we appeal to the patriotism of these dual citizens when we are trying to sell diaspora bonds and so on. Then it doesn't really ring honestly when it comes to political office to say, well, we doubt your patriotism. If you doubt their patriotism for holding political office, why do you trust them when it comes to selling diaspora bonds or even encouraging them to send you their remittances? The third reason is practical. Any system that excludes 10% of the population from parliament, from sitting on the apex court, I mean, somebody like them from sitting on the apex court, from holding all these other offices, have to come across as fundamentally flawed.
Okay.
It's one thing excluding them from 1 or 2 offices.
All right.
But the breadth of exclusions is just extraordinary.
All right. Thank you. Now, Justice, we have actually passed a law to allow Ghanaians who live elsewhere, whether you are dual or you are not, to be able to vote, to register to vote and vote from those countries. The court has actually upheld, that law. Many other countries do the same. So if we give them the right to vote, why can't we give them the right to be MPs, the right to be judges and all of that?
Well, I mean, we need to separate the right to vote from all these other, because, for example, if you're Ghanaian and you have resident permit in the UK, by mere fact that you belong to the Commonwealth, you can vote. But that right doesn't translate into you running for other offices and occupying certain positions, even with your nationality not being British, So we need to be, we can't mix the two. But the point which must stand out is that there is a purpose behind all these, limitations that we have put on certain citizens. There is a purpose. I believe that we can still achieve those purposes without the explicit restrictions that we have done.
Okay.
What we need to do is to go much into details, admit some of the fundamental legal principles, and then make a decision whether we want it to go this way or not, because there is always a way to achieve that purpose without the exclusions that we have put in place.
All right.
So what I would pray is that even as we discuss this bill, we should not, it is not a win-lose argument that we should create strongman arguments in order to win people's support for it.
All right.
We can still admit certain things,
okay,
and then make a political decision that, okay,
right,
regardless of this is where we want to go.
All right,
that is how I want the debate
right,
to be.
time just ran out on us, and I'm sorry that we couldn't engage you also. My production is talking about maybe doing a part 2, but we'll think about it and make a decision as to whether we should. My guests have been Professor Kweku Asare, D&D Fellow in Public Law and Justice, CDD Ghana. Dr. Justice Shramsai is lecturer at Gimpa Law School. And we have been discussing citizenship versus allegiance, the complications of a dual citizen. And so anytime you want to pick up the citizenship of any country, think twice about it if you're a Ghanaian, until this amendment carries through. I'm Samson Ladi Anyanini, and this has been The Law. It's your legal light and your health law. Once again, thanks to Joseph Akable for sitting in whilst I was away.